Is it looking like people have had a chance to join, Nikki?
Yes, and I'm just pinning our speakers right now. We got Amy, Beth, Maddie. I'll remove your pin when we're done. Go ahead, Maria. I think we're good to go.
All right. Well, hi, everyone. My name is Maddie Nelson, and I work for Standpoint, and I'll let Nikki introduce herself.
Hi, everyone. Nikki Engel from Violence Free Minnesota.
All right, so today we're hosting a Q&A on orders for protection and harassment orders. And we're doing this because Standpoint's action line has recently received, excuse me, an influx of questions about them from advocates and victim survivors. And what we're seeing is that a lot of the same questions are coming up over and over. What we're thinking what might be happening is that there are just a lot of new folks doing this work. So we felt it might be a good use of this space to go over some of these more commonly asked questions. We also sent out a survey link where you could submit your questions, and those entries have been provided to the presenters. My guess is that we won't have enough time to get to all of them, but if you do have additional questions during the presentations, you can type them in the chat and we'll do our best. And then, of course, if you have any questions that didn't get answered, you can always call us. And I want to note that this meeting is being recorded and will be uploaded to Standpoint's YouTube page. So if you have others in your organization who are maybe new to writing orders or just want to understand them better, please let them know that they can find this there. So joining us today are Standpoint staff attorneys Beth Assell and Amy Edwall. Beth's been with Standpoint since October of 2020 and primarily advises in the areas of family law, OFP, HROs, and criminal expungement. And Amy joined Standpoint just last month, and she advises in the areas of child protection, civil and criminal law matters. And then in addition, we also have Malia Garza, who is the domestic and sexual violence analyst for state court admin. And she's just very knowledgeable when it comes to these forms. So we've invited her to jump in just if there are any questions that come up that she'd like to comment on. Okay, so with that, I will turn it over to our main presenters, Amy and Beth.
Okay, thanks, Maddie. And thanks everyone for coming and for sending in your questions. So we did Amy, I should not take any credit. Amy put together a PowerPoint on the questions we did receive in advance. I think we tried to get to them all. So I think we can just jump in. Like Maddie said, if you have questions along the way, if it's like clarifying something that we're saying or a new question, feel free to pop it in the chat and we will get to it as soon as we can. Anything else you want to say, Amy, before we jump into the first one?
I don't think so.
Okay. So some of the questions we got, kind of the background on this slide, some of the questions we got were more general, such as what's better to file, an order for protection or harassment restraining order, or which one is more likely to be granted, which one is more likely to give my client relief. And we didn't want to have a slide that just says, it depends. So we put together some pros and cons and maybe some differences between the two that could help people decide. So I guess I can start, Amy, and then if you want to, we're just more casual than a usual webinar. So we're both just kind of weigh in on each slide and what we want to add to the topic. Well, one difference we wanted to point out for people is that in an order for protection, you can ask for temporary custody and temporary parenting time. That may be a really obvious thing to say, but I think it's a good thing to keep in mind too. Because we touch on this on a later slide too, but if a petitioner files an order for protection and there's joint children in common, and the dad is an adjudicated dad, even a recognition of parentage, he can use that proceeding to ask for parenting time. Sometimes that's a real risk for a petitioner and the children and a risk that they don't want to face. So just to be aware that an order for protection can have that temporary custody and parenting time. Sometimes people want that, and so that's a benefit. And they can override existing custody and parenting time orders, such as in a divorce decree. But if you have a client who wants to avoid the possibility of parenting time coming up at all, an HRO, that is one benefit of it. There is nothing in the HRO statute that says parenting time can be addressed. The relief in an HRO is limited to no harassment and no contact. Do you want to go, Amy? I didn't know if you were going to say something. Okay.
I mean, I agree with what Beth said here. It is really risks and benefits. Some people really need additional relief that can be provided in an OFP. And sometimes people have a custody order that allows for contact that's no longer safe. And, you know, the benefit of an OFP there is you can go back and get some relief immediately on that earlier order. If you are really concerned that an adjudicated parent or rope dad is going to come to court, you know, it might be safest just not to address it and stick with the HRO. We do get a lot of questions about, you know, which is better. I guess speaking very broadly, an OFP, you know, carries stronger protections. It gets flagged in a lot of places. You might have an easier time with enforcement. Typically penalties, especially for subsequent violations, they stack up more quickly and stronger than HRO violations. So that's something to consider. And one question that I think we've seen a lot, because these OFPs, you know, you have a, I don't want to say low, but comparatively low standard to get an extension or a subsequent OFP. All you need is reasonable fear. You do not need a new act. That is not the case with an HRO, so that's something to consider. If you don't have a new act of harassment, you're going to have trouble getting a new HRO after the original expiration.
And yeah, and we've heard of some judges telling people, oh, don't file a new HRO, you have to file for an HRO extension. But that's not a thing. There's no forms for it. The HRO statute doesn't allow for it. So that's definitely a difference. One other thing we just wanted to note was in the order for protection statute, it specifically says that testimony from a respondent can't be used against them in any criminal cases. Just something to note that maybe if there is a criminal case that's related to the order for protection, if you file an order for protection, the respondent may feel more free to challenge that order and testify because the statute specifically says their testimony is protected. The harassment restraining order doesn't contain that similar protection for a respondent. What that could lead to is maybe they're more likely to agree to an issuance of an HRO without findings to bypass anything they say in the HRO proceeding being used against them in a criminal case. All right, are you ready for the next one, Amy?
Sure. Actually, I see that we have a question that I want to ask Malia about, maybe, because it looks like there's a service of process with Mindy's, the new digital exhibit system everyone is still getting used to, for folks to serve. And I have noticed that you do get confirmation when the other party gets your documents in Mindy's, but is that service of process under the statute? I don't know. So that's a good question.
That's my question.
Sure, I'll jump in. The short answer is we are still figuring that out. Generally speaking, most courts do not consider that to be sufficient for service. And the reason behind that is there is no internal mechanism within Mindy's that allows the court to see that, yes, in fact, those exhibits were shared. So it's in part a limitation of the tool itself. And then we are also having a bunch of conversations internally about what, you know, how involved can the court be involved in this process, et cetera. We recognize that we're very quickly in a different world than we were before, when people would bring their exhibits with them to court and simply show it to the other party. Typically, the courts have not been involved. And so this is kind of asking us to take on a new role. So unfortunately, no clear answer, but that is at least why you may be getting that message that uploading and making, sharing an exhibit through Mindy's is not sufficient in terms of serving that on the other party.
And I think that leads in well to this next slide we have and a question we got about what is the best way to submit evidence to the court. And what we were discussing with Malia prior to starting this presentation is that courts statewide are moving towards using Mindy's as the system to submit evidence. And that would be whether the hearing's remote or in person. I think the advice we're going to have to start giving callers is that they need to get used to that Mindy system. And I know there's a whole section on the court's website about Mindy's, including instruction guide. I think there's a video on how to use it. Okay, looks like yes. And submitting evidence along with the petition, we're also asking Malia about that. And it's in guide and file, it sounds like maybe not possible, or
Yeah, if you were doing it through guide and file or using EFS as your filing tool, you would just want to make sure that they're not all lumped in together with the petition as one single document. So for example, there is a separate case event to use if you had a law enforcement report, just as one example. But generally speaking, it should not be all, don't just handle the whole thing as one single petition.
okay. And then before we move on, I wanted to address one of the questions we got. It says, random question, does an OFP override a DINCO or vice versa? So Amy, if someone had an OFP and a DINCO at the same time, which is common, I know sometimes callers wonder, if I have a DINCO, why would I need an order for protection too? And I try to explain that, DINCOs are not up to you. Like if something happens to the case, or like it gets downgraded, or if the case is dismissed, that DINCO is going to go away and your protection could just be gone. So there's an obvious benefit to an order for protection because you have a certain amount of time. There's other relief you can seek, but I do sometimes see that they aren't, they have conflicting relief. Maybe the DINCO has an exception for contact that the order for protection doesn't. I don't know about you, Amy. I don't necessarily see them as overriding one another, but just if I was advising a respondent, I would say listen to the most restrictive one and try to get them amended so that they match.
I agree, Beth. I think neither one overrides the other. I think a lot of times, you just end up with conflicting language because they're different courts, different proceedings issuing these orders. I think it's a really good way for victim witness advocates to be involved, to communicate what is in an OFP is one is accident, so that you don't end up with that problem. And I do think it can be confusing for victim survivors because sometimes without their knowledge, maybe there'll be an exception in a DINCO for contact between the parent and the kids when the OFP says no parenting time. My position on that is, if the OFP says no parenting time, there's no parenting time. But I agree that it gets confusing, especially if law enforcement has to be involved, because they'll see an order that says, oh, contact's permitted. So I think for advocacy, it's really helpful to make sure that the criminal court is aware of the provisions in an order for protection or an HRO, so that they can make sure those match and we don't end up with enforcement issues down the line.
I agree. I had a client in a divorce once with an OFP that was really restrictive, really protective. And then one day her abuser was calling her because he asked for an exception for phone contact in the DINCO, and the court gave it to him with no notice to her. And it's a shock. It's not good practice, but I would agree, try the best you can to make them match. Okay, so another question we get asked a lot, and we got asked again, is the standard of evidence for a joint child to be listed as a protected party. I know a lot of the calls we get, it's really common for parents, this is obvious, to want to protect their kids. And so if the petitioner is a victim of abuse and there's abuse in the home, or the other parent's doing something to scare a child, they want that child to be a protected party along with them. So the standard is that for the child to be a protected party, and by that we mean actually like listed on the caption, like it's not only on like for petitioner, but OBO a child, that child has to be a direct victim of abuse. And that's direct victim of any of the things that are listed in 518B.01 that Amy has listed here. So they have to directly be a victim of physical harm, the infliction of fear of imminent physical harm, or there has to be terroristic threats directed towards them, criminal sexual conduct directed towards them. And that's where you kind of get into the distinction between them being direct victims of abuse or I don't want to say just or merely, but just they were just present. One thing one thing that should be possible under the order for protection statute is even if a child can't be a protected party because they're not a direct victim, the petitioner should still be able to ask for temporary sole custody, restricted parenting time for the other parent. And that's a different standard. The standard is what's safest for the victim and the child. So and you are allowed to, the court doesn't have to consider, but they can, all of the best interest factors that are also relevant to divorces in custody. So it should open the door to bringing in a lot of things that aren't abuse, but still impact what's safest for that victim and child. It doesn't always work that cleanly, but that's how the statute is written. Anything you want to add there, Amy?
No, I think we get into this a little bit in a later slide, but I think this is one area where you do want to be really thoughtful about the custodial status of these kids and whether there's an adjudicated parent.
Yeah.
Because this is one of those areas where if there is no adjudicated parent on the other side, on the respondent side, and you don't, want them coming to court with a rope and trying to get parenting time, it could be easier, especially if you don't have a real strong case showing direct abuse of that minor child, to leave them off. But we can get into that, I think, a little bit later, because I think we have a slide that particularly talks about it. We do have a question too about, a great area in terms of immediate fear of harm. And I think, it's vague language and judges are going to interpret it differently, especially on an ex parte. My best advice there, I think, is to be as detailed as possible in writing your petition, and specifically say, we say this a lot, but don't just say, he yelled at me, but say what exactly it was that put me in fear of harm. Were they getting really close to my face? Were they yelling certain things? Has there been a history of abuse that made me believe that it would happen again this time? So really talk to the victim survivor who's writing that petition and say, what exactly, details made you believe that you were going to be hurt? And I think that judges, are certainly going to interpret it differently. I feel like ex parte relief is a tough thing, and some judges, expect a lot of detail in order to grant it. So the best thing that you can do is be as detailed as possible. If you're filing in person, you can certainly attach some evidence. If you're filing on guide and file, we're not sure if you can. But trying to get all those details in so that the court understands the context, because physical harm, you can make that allegation, you can say what they did. Infliction of fear really does require context for understanding.
I would agree. And I wish we could give a lot of clarity. But like Amy said, that's the language, like what we have on the screen, and what judges do with that is what they're going to do with it. But I would find that when I talk to clients, once we got into it, I'm like, okay, we have something here to show the judge. They'd be like, well, no, he or she, they never touched me, but they would pursue me around the house, or really get in my face, or stop me from leaving, or they would shatter a vase by my head. Those are the kinds of things you want to include to show that why in that moment that petitioner felt that the respondent could have hurt them. And I've definitely had OFPs that are successful, without any physical harm at all, just that infliction of fear of imminent physical harm. But for some judges, it's going to be tougher. See, we have one more question in the chat, and then it looks like we have a raised hand. Do you wanna, should we handle those before we move on?
Sure. So do you want to start with the chat here? When the judge won't entertain relief that requires a hearing, I feel like that is not uncommon. And it can be fairly county specific. What are your thoughts on this, Beth?
Yeah, I would agree. I mean, I think there are some counties where I just know that if if I provide advice in those counties, or maybe even ones I practice in, I just know that judges like to really keep things separate. Like they think an order for protection is for no contact and just protection, and that anything else should be handled in family court. I don't know what to say other than the petitioners have a right to keep asking. They have the right to make an argument that it's in the statute and why it's safest for them and the children to have that ordered then. But you know, the statute that talks about the relief that may be granted, it says, you know, upon notice and hearing, the court may provide relief as follows. So it's discretionary. They can provide relief like the temporary custody, child support, and things like that. So if they, in cases where they're married and they both legally have the same rights to the children, and the court won't address parenting time in an order for protection setting, I guess I don't know, and they need that order. I don't know what to tell them in that situation, other than a family court case, divorce, legal separation, something like that to get that order.
And I think agreeing with Beth here, I think it's a judgment call. I think we're all aware that, you know, judges have their preferences about how, you know, these matters should be handled, and some are very reluctant to address it. And I think that you can tell, you know, your clients, the petitioner, you have a right to that hearing. You do. You can bug the judge and try and get them to give it to you. But the consequence of that might be that they still tell you to go to divorce court and decide you don't need relief right now in your OFP.
Yeah.
So that's something you're going to have to weigh. And I think you want to consider whether they're in a place where they're willing and able to commence a family court action or a divorce action in order to, you know, get that process started in determining how important it is to push back on your right to that hearing. It is frustrating because you do have the right to that hearing, but you have to think kind of big picture about what's going to get you to where you want to be the fastest. And then Janet, I don't know if we can let Janet talk here. I'm not sure how we do that.
Oh, I think, can you hear me?
Yeah.
Hi, I recently had a case where I went with my participant to an OFP hearing. There's evidence he was arrested the day, and now he pled, he's in a plea deal, which is gonna be submitted this week coming up. But the judge didn't even give her the ex parte. He didn't give her that, even that option in the initial hearing. He said, well, there's a divorce hearing coming up. We're gonna have you go to that one, and didn't even address, I guess, her concerns for safety. There is a DANCO in place. I mean, what could I do at that point to advocate, because she wasn't represented, and then I felt like she wasn't even heard. When there's, you know, evidence that we submitted before that hearing that he could have seen, I guess.
And just to make sure I understand, it's just that the judge wouldn't address custody and like the custody and parenting time issues, or the judge wouldn't even address the order for protection?
He didn't even address the order for protection. He just said, we're gonna wait until after the 30th because you do have a divorce hearing there. And I just don't think she was heard at all. Because yes, she asked for custody, but I mean, her concerns as far as, you know, I was chased with a weapon didn't even like matter because she didn't even get the ex parte. I don't know. It just felt, I don't know. I raised my hand and kind of be like, hey, what's going on? I kind of talked to her a little bit for her in the court, but I didn't know how far I guess I can, you know, be involved, as well as he mentioned that the abuser, the respondent, wasn't served, which he was. I raised my hand and then he caught it that he was served. So I don't know. It's those little things like how much can I do to kind of help her and say, hey, she does need, you know, at least the ex parte until the next hearing
Right.
because she wasn't granted it.
I don't know if I've seen that exact situation, but I do know judges do sometimes have that opinion that everything's best dealt with in family court, but it even says in the order for protection statute that an order for protection can be granted regardless of any other actions that are occurring between the parties, which includes family court. So it could be a matter of trying to point out that language to a judge. I don't know the best way to do that, like in the hearing saying, pointing out that part of the statute. Sometimes afterwards, I know parties will write letters to the court asking them to reconsider or to hold a hearing based on language like that. Amy, Malia, I know you came on. I don't know if you had anything you wanted to add, but please feel free.
Sure. I'll just add, I mean, generally speaking, individual opinions, including a decision about granting or not granting relief, can be appealed. I do know that not everybody has, you know, it doesn't feel like a realistic option for all people because of both timing and costs, but I just wanted to put that piece out there. The other thing that you can do, Janet, is you can send an email to me. You know, I can't intervene on individual cases, obviously, but I do routinely hear concerns or issues that are raised from advocates around the state. And what that allows me to do is flag that as a potential area for training. I can look into practices in that particular county or that particular judge just to see, like, is this a pattern? So you can certainly reach out to me and I can add my email address to the chat so that everybody has it.
Please. Thank
But
you.
that's just one more option,
And
even
I
though
can-
it may not change the result of that particular case.
Thank you for that. I will let her know about appealing if that's something she wants to do. It's just like you guys mentioned, there was a threat, you know, and she was chased with this weapon. There's court documents. He pled now. So it's just like, how far could she go where the judge didn't even offer the, you know, that she was going to give her the ex parte. It was just baffling to me because that doesn't really happen. So, and I haven't worked with this county. This is like my first or second case. I'm usually more within the Twin Cities, but I guess, well, it's just astonishing that's happening.
Yeah, I agree. Well, thank you for sharing that. Did you have anything to add, Amy?
No, I think it's great that you have the option to let Malia know so that those issues can be addressed. And I guess the only thing I would say, if the petition, alleges abuse, you are entitled to a hearing, even if the judge, thinks that your DANCO's enough, so you don't need ex parte relief. So one thing, if they want to kick it out, and I think sometimes judges are used to dealing with represented parties and they're hoping a settlement happens. So one thing, that you might do is try and, get that ex parte hearing scheduled for a future hearing date, just to make sure that the court is aware that it does still need to be addressed and it's not going away. But it's a tough situation, that one for sure. And it is appealable. If you allege domestic abuse, you're entitled to that hearing, even if you don't get ex parte relief.
And if it's helpful, it's section 4D. 4D is in dog of the OFP statute, which is 518B.01. Says the court may not delay granting relief because of the existence of a pending action between the parties or the necessity of verifying the terms of an existing order. So that's what I was mentioning before, when the statute specifically is telling courts it doesn't matter if there's another case. Okay, so the next slide we had, I know we've touched on this, but one question we got specifically was, should a petitioner with sole custody request custody or parenting time relief in an order for protection? And one thing we just wanted to note is that if you check the box on a petition asking for custody or parenting time, is going to trigger a hearing. At that hearing, a father, even if they even if there's no custody case, even if they just have a recognition of parentage, they can use that hearing to request parenting time. Kind of depends on your county. We're talking about counties that are refusing to address parenting time. I know other judges who are going to grant parenting time no matter what. It's kind of a matter of knowing your county and your judges and what they're likely to do, but just know that requesting that custody and parenting time is going to trigger a hearing. They can use that hearing to ask for parenting time. Of course, they always have the right to request a hearing no matter what. Even if an ex parte is granted without a hearing, they have that 5 days after service. But maybe it's just a matter of making it less likely that there's going to be a hearing.
I agree with Beth. I mean, and it is important to know that even if you only request 7A relief and you don't request that parenting time be addressed, respondent father can still ask for a hearing and ask that it be addressed. But in our experience, not having the hearing and not having the kids on there just makes it substantially less likely that that's going to happen, because respondent is going to have to take a lot of steps to make their request and ask for a hearing and go to court. Right. So oftentimes, if you don't ask for it, they won't either.
Yeah, it's true. Thought we had a raised hand at one point. Did we answer the question?
You did, sorry.
No, don't be sorry. Okay, good. I'm glad we did. Okay. Okay, what else we got? Kind of each slide is kind of a surprise to me because I forget what's next. Okay, this is the good one. Is it worth requesting programming or chemical/mental health evaluations in an order for protection? It depends. Yeah, probably depends, but leaning towards no, probably not worth it. Just in our experience, we can talk about our experiences more, but that's another example of something that's going to trigger a hearing. I know that's been really surprising to some of my callers. They've said, like, I remember a caller like, my sister didn't have to have a hearing and hers, why did I? And we looked through and it's just because she checked a box that she wanted the respondent to do a chemical evaluation or something. And so the court, it triggered a hearing. She didn't want to go to court. It was really upsetting. So keeping in mind, do you have any other relief that requires a hearing? If programming is literally the only request that's going to require a hearing, is it worth it? Maybe not. In my experience, judges don't really like to order that programming. They either kick it to family court, or if parties don't have kids together, I think judges don't see the point. And I think there's also concerns with judges about who's going to monitor this, who's making sure that they're doing it, who's in charge of making sure this happens. And there's not a good answer. I know Hennepin County for a while was having review hearings to make sure this happened, and it was good, but that was part of a special grant, I think, and I don't think that's happening anymore. Well, you, Amy, anything to add to that?
I agree. I think courts are reluctant to order it. If it doesn't happen, well, you know, maybe you could raise that in your custody or parenting time case or divorce that they didn't do it. But the risk benefit, I think, and especially weighed along with the reluctance that I've seen in ordering it, in my opinion, unless, you know, there's a real specific reason, if that is the only relief you want that's going to require a hearing, in my experience, usually not worth it. But, you know, circumstances can vary.
And I told I remember one caller, this is the only relief that he wanted. And we had to talk about how it could trigger a hearing. Maybe that's not worth it. But if the other party did request a hearing, maybe you can make a request to amend your petition and add this in, you know, something to consider if it's really important to you, if there's going to be a hearing. Okay, let's move on. Okay. Question about, can minors with children file an OFP on behalf of themselves and their children? So the statute, this is one question I think the statute is actually really specific on, that there's pretty limited times when a minor can actually file on behalf of themselves in terms of an order for protection. Only if they're 16 or older, and they can only file against a spouse or a former spouse or someone they have a child with. But the court also has to determine that the minor, so the minor who's the petitioner, has sufficient maturity and judgment and that it's in the best interest of the minor. So I've only had one case where a minor filed on behalf of someone they had a child against, but it was no issue having the court make that determination about their maturity and judgment. I haven't seen a minor file on behalf of a minor, but we were just thinking it would go along with the part of the statute that says, a parent can apply on behalf of their child. I think as long as a minor, age 16 or older, meets that really specific requirement of they can only file against a spouse or someone they have a child with, then yes, they would be able to file on behalf of their own child too, as a protected party. Okay, this is a big one. Amy, do you want to, I've been kind of talking a lot. Do you want to start on the property question? I know we get this one a lot.
Sure. So how to address it, how to deal with it, more importantly, when the property does not get picked up as ordered. So we do have some slides in the coming slides here about it, but we also have on our website under housing a little fact sheet that kind of guides you through the details. So feel free to go to standpointmn.org if you want to see the details. At the outset, we suggest asking that this order, whether it's stipulated or whether you're asking the court to order it, be as specific as possible.
Yeah.
If you want a police escort, do be aware that the police might have different ideas about what their obligations are in terms of hanging around and whether they should be paid for it.
Yeah.
But we do ask for a specific police department, ask for a date, ask for them to coordinate the date with the police department, ask for them to get all of their stuff. If you can get the judge to do it, get them to write in that if they don't get their stuff, then they have left their stuff and they have no more right to the stuff. I mean,
Exactly.
the more details that you can include here, the better. Because we see it all the time where people are left with a bunch of stuff and they're worried, rightfully so, that they're going to get sued at some point if they get rid of it or sell it or don't act as this person's, storage house for a number of years. So when you have addressed it and this person has still not retrieved their belongings, how do you address it? Well, there aren't great options, but there are a few. This is my preferred option because it is fairly low risk for getting sued later on.
Yeah.
But it does require some work, and you have to wait. I believe it's 6 months. I think I have the statute on the next slide. And if the person has not removed their property within 6 months after it comes into the possession of a person, I haven't seen a case on this, but I would count that as from like the date the ex parte or at least the final OFP was ordered. I'd start that 6 months. It's abandoned, and you do, however, you have to know where they are. Because you got to send them either personal notice or notice by certified mail. And you can just send a brief letter if you're able to do that, know where they are. Certified mail, which is actually received, or personal service. And you can say, you had the chance to get these items. If you do not pick up your items within 30 days, I consider them abandoned, right? Yep. Keep that letter, keep your proof of service. And I would say after 30 days, you can get rid of it or do whatever. And the person shouldn't really be able to come back to you under this statute as well, because it is considered abandoned property. If you were to sell it, I would be careful if it was something very expensive because they might get mad. But the statute does not say that it's not their property anymore. So in theory, at least, you should be legally in the clear if you sold their stuff, kept the money. Now, the big issue with this is you have to wait 6 months and you have to be able to find them because they do get
address. Yep.
So legal action, you can bring them to court if you meet, which most cases of personal property will fall below that conciliation court standard. Take them to conciliation court. Say, this person hasn't come and retrieved their items and I want a finding that they're abandoned. They might show up and come get their stuff because now they have notice that it's going to be removed. Or they might not, and hopefully you can get a finding from the court that this property is abandoned and you are legally in the clear to do whatever. You don't have to give notice. I mean, you do have to give notice, but you can do service by alternative means. You know, there's no actual notice requirement here to bring that case. So if you can't find the person, if they've disappeared, if they've left the country, this is still an option to get an order that is enforceable. And you also don't have to wait 6 months. So that's a benefit. I would recommend waiting more than, you know, a month or two, but I don't think you'd have to wait 6 months. Again, proceeds from the sale of property would not have to be returned once you have that order.
And then I know Amy referred to, this is all, these slides we have here are all on our website under the housing law section that our housing team wrote up, and it's super helpful. I refer to it all the time. The last section is just if the petitioner and the respondent have had a landlord-tenant relationship, there's specific things that landlords can do to dispose of property. That may not apply to a lot of these situations, and without a lease, I think it's tricky if someone's considered a resident. So that's a resident, however they define it under the eviction statute. So I would say if you're thinking it's a landlord tenant, definitely call our housing team first just to talk that through. But like Amy said, the best, if you can think ahead and get that, you know, get an order that says they have one time to get their property. If they don't get it within a month, that's the best. So you don't have to go through this, but not every judge is going to entertain that. So these are just kind of backup options. The safest one probably being that waiting 6 months and giving the notice. Okay, so I saw one chat that maybe we can touch on before we move away from property. How do you deal with schools that are telling the petitioner to get an order on behalf of kids where there's no grounds for this, other than raising this in the petition and hoping the court put this in the order? Any other options for the petitioner to address this with schools? That's a tough one. I think that's kind of along the lines of like CPS telling parents to get an order for protection for their kids when there's just no basis. Maybe there's really legitimate concerns, you know, like poor parenting, drug use, all kinds of possible things, but no basis under the statute for an order for protection. Amy, I mean, the first thing I think of is that if the petitioner themselves has a basis for an order for protection, just ask for the school as a protected address. I've seen that done successfully, just on the argument that even if the kids aren't involved, petitioner has to go to that school regularly for conferences and pickups and drop-offs and whatever it may be, and they need to be safe there. And I don't think judges have given me much pushback on that. Have you seen anything different?
I agree. I haven't, now to be fair, I haven't seen somebody actually contest it, but I have definitely seen folks write down the kids' school. And I do think you have a good faith argument to say, you know, I have to take these kids to and from school. If I have a right not to be in contact with the respondent, you know, I need him to stay away from the school. Potentially that could be challenged, but I think that would be a good way of handling it. I certainly understand that, you know, schools sometimes have safety concerns as well. But, you know, I think if you requested that relief, if you filed only on behalf of yourself, but also asked for the school to be a protected place, it would be worth your while to include some facts about why it is that the school wants that. Is the respondent showing up and causing trouble? Have they threatened to kidnap? I mean, what is the school afraid of them? I mean, write it down so the court knows why, even though you're not asking for the petition to be granted OBO the kids, why it is that it makes sense for the petitioner's protection that the school be included as a protected place.
Exactly. So they don't think you're just trying to like exclude the other parent for the sake of excluding them, but there's a legit safety reason. What do we have next? Okay, so a little simpler question. We got a question about order for protection extensions. I'm a big advocate for filing for extensions or subsequent orders rather than brand new petitions because it's a lower standard of proof. We kind of touched on that in our first slide, but you just have to prove violations or reasonable fear rather than brand new trying to meet that order for protection statute, how that defines. That you don't have to show that physical harm has happened or that fear is imminent. I think it's great. And that is even even if an order is expired or the petitioner voluntarily dismissed. Under the plain language of the statute, they should still qualify for a subsequent order with this lower standard of proof. But when you file an extension or a subsequent, the hearing requirement is the same as for your initial order. It'll depend on, a hearing will depend on the relief that's sought. So I know, next slide, Amy, you specifically list places the relief that does not require a hearing, right? Yes.
Yeah, so here's your 7A, no hearing required relief.
Yeah, so if you kind of stick to the basics, right? Like no abuse, no contact, don't come to the home, don't come to my work. Pets fits in there, insurance fits in there. But if you stick to that, there should not be a requirement for a hearing. I think if there's more complicated relief, or if you were to add new things from the initial order, like, okay, I want to extend my order for protection, plus now I want child support. I don't know if I've seen that done, but I suppose you could try. There's going to have to be a hearing on that new topic at least.
And I think that fits in well with the question about forms for HRO extensions. So this is a big difference between the OFPs and the HROs, is that you don't get HRO extensions. So that's not statutorily authorized. So if they violated, and if they have a criminal case, or if there's new stuff that's happened, you can file a new petition, but you don't have the ability to go and get the original order extended. You do have to file a new petition. You have to allege new acts that constitute harassment in order to get relief under the HRO statute.
Yeah. I know we got a question. We've attempted to file the subsequent OFP form and it's not been successful in ANOCA. I guess that doesn't shock me, but for questions like this, I never know exactly what to say other than I think they're wrong. I mean, the statute is pretty clear that it can be extended, or if it's no longer in place, you can file for a subsequent, and there's nothing that says that first order has to be in place the whole time, or it couldn't have been voluntarily dismissed. But I know also judges are gonna do what they're gonna do. And we have a question, what's the difference between an extension of an OFP and a subsequent? An extension is just when you file when the first one's already in place and you're trying to just kind of have a seamless extension. I get, just have it for another 2 years and file it before the first one expires. Subsequent would mean that that past order is no longer in place. And someone said, I know there hasn't been a form for HRO extension, so can we do a modification to request the HRO being extended based on violations and our criminal case is still pending? Okay, Amy, I don't know about you, but I would say for an HRO, you should not be able to modify to extend like the deadline or how long it's in place. I know there's been some case law that I've sent to other parties that it says a court has concluded that a court may not extend a restraining order beyond 2 years from the effective date of the initial restraining order. So essentially, I think there's case law supporting that you really can't extend an HRO. The only thing it says in the statute is that you can apply for a 50-year order if you've had, I think it's 2 or more HROs in place or there's been violations, but there's just really nothing that allows for that in extension. Will a court allow it? Maybe, but is that an appealable if they do? Probably.
That's my read as well, Beth. In subdivision 5, it does say that, a restraining order may be issued for up to 50 years if there's been 2 or more previous restraining orders. But since it speaks specifically to those previous restraining orders and violations of those, it's my read that that is a new action that you would have to file for a new petition for a 50-year HRO. And, if you've had multiple violations, that should go a long ways towards getting you over, the new burden. But I don't think that it would be allowed to extend it. I'm not saying you couldn't give it a shot, but I haven't seen it and I wouldn't really recommend it.
And just in case it's helpful for the order for protection, extensions, and subsequents, it's subdivision 6A of the statute. So that's 518B.01. And all it says is upon application and notice in a hearing, the court may extend the relief in an existing order for protection, or if an order for protection is no longer in effect, when an application is made, grant a new order. So that's where kind of my argument comes into place, that it doesn't really, as long as that first one was granted, shouldn't matter if it's no longer in place, or if it was voluntarily dismissed, they should still qualify for a subsequent, but I know not all judges feel that way, and some people do have trouble.
What was that, the statute again? Could you repeat that? I'm sorry.
Sure, no, so just the order for protection statute is 518B.01, and then the part that talks about extensions and subsequent orders is subdivision 6A. Well, look, we actually kind of,
Thank you.
You're welcome. We actually kind of answered this next one already. It's just, when should they request this? I mean, a subsequent is anytime you need one. Just knowing that, yeah, some judges may not understand or agree with me about that reading of the statute. And if it's an older order for protection that hasn't been in place, they may not see it as a subsequent. I still think it's worth a try. With an extension, we just recommend waiting about 2 or 3 weeks before expiration to file the extension request. Okay, gosh, Amy, I think we're gonna run out of time. We're getting into some evidentiary stuff that we had questions about. One is, how do you determine whether a petitioner has helpful witnesses? We just listed some guidelines. I think the main thing courts want to hear is from people who have direct knowledge of the events in the petition. So they don't want hearsay, what we get into next, like I heard it from this person who heard it from this person. They want, you know, direct knowledge. And that can be if they were there, but also, like Amy put on the slide here, if respondent admitted the abuse. I've had success with witnesses who maybe they weren't there, but petitioner called them right after the fact and they were really upset, and they can just kind of testify to that state of mind or kind of how they've seen them react after an incident. And then professionals, of course, you know, CPS workers, medical professionals. What was I going to say? A common question we get is if petitioners can just include a statement from a witness, like a letter. I totally get the question, but I always say no, because it's witnesses have to be present and testify and then be subject to cross-examination too. Otherwise, the court just can't accept that witness statement. And witnesses who are just coming as like a character witness, petitioner is a great person, aren't going to be as helpful in an order for protection. The court's really kind of focused on those facts and whether or not domestic abuse has occurred. Gosh, what does hearsay? Just saving a small one for the end.
Yeah.
So hearsay is a really common objection you'll hear in an order for protection. OFPs, like any other case, are subject to the rules of evidence. Hearsay officially is an out-of-court statement that's submitted to prove the truth of the matter asserted. Statements of a party opponent are not hearsay. So a petitioner can get up on the stand and say what respondent said to them, what they heard them say, what they said during an argument. You know, that's not hearsay. It's more if you got up on the stand and said, my grandma told me she saw this. That could very potentially be hearsay. And that's a pretty common objection, especially if there's attorneys on the case. Amy, do you want to try and tackle any of these exceptions, these common exceptions? Okay.
Well, in the interest of our last 4 minutes, I probably won't go through all of them, but just keep in mind, if you have hearsay questions, you can always call us because it is a complicated area. Big ones we see are, you know, excited utterances, if someone's under the stress of a major event at the time they made the statement, prior inconsistent testimony under oath, if someone said something else in a previous statement that they made under oath, maybe a previous affidavit, they can be impeached with that in court. Statements for the purpose of medical diagnosis or treatment, also not hearsay, important in cases where there may have been injuries. And also some of your documentary items, judgments of previous convictions, if you want to get those in, records of vital statistics, birth certificates, marriage certificates, those kinds of things. Regular business activities, there's also public records exceptions. Those are typically not hearsay, although often you'll need the person, the police officer or the worker or whomever to come and testify as to the authenticity. But there are several exceptions. These are just some common ones. And then there are some particular statutory exceptions for child victims as well. And we do get asked about those a fair amount. I think that's like a slide. Oh, here it is.
Yep.
So this is one that we do get asked about a fair amount. Statements of children under 10 also applies to mentally impaired individuals. Describing sexual contact or physical abuse. Keep in mind, if you want to raise this, the court has to make some particular findings, and you are required to give the other side prior notice that you want to introduce that out-of-court statement. So we recommend putting it in your petition what the statement was, so that it's clear that the person had notice when they got served with the petition that this is a request you're going to be making of the court. And I think our next slide goes into what the court has to find.
Yes.
So that might be a good moment to wrap up then. We are out of time. I know there were a lot of questions, both in the PowerPoint and in the chat that we weren't able to get to. And then there was a request in the chat to have the PowerPoint sent out to everyone, which is something will be able to do. But just a reminder that we really encourage advocates to call Standpoint with any other questions you have. So with that, I want to thank Malia, Beth, and Amy for being here today. Thanks everyone for submitting your questions and participating. And then Nikki, did you have any announcements before we end the call? I'm going to take her.
No, sorry, sorry, I was finding my buttons. No announcements here. Miski, I'm not sure if you're asking about a phone number. Standpoint, would you mind putting your number in the chat here? Miski, I think it might be beneficial if you could reach out to Standpoint if this is a matter of getting your advocates kind of the right training, or if this is an issue of judges not tending to grant them for your clients. I think we need to dig in a little bit more. So if you can give Standpoint a call and maybe ask for Beth or Amy or Maddie, maybe we can dig into that with you. But otherwise, thank you so much, everyone. Maddie is going to post, I see a question about the actual presentation that will be posted on Standpoint's YouTube page, and then we'll get the slides out to the attendees. But
And
that's
that
all I have.
one thing I would just add is that we had some questions about firearms that came in that we didn't get to. Rena did a really good 1-hour training on firearms. That's really extensive and it's only an hour, so it's easy to watch. I would recommend that people go watch that to get the best answers on firearms.
Absolutely. All right. Well, thanks so much. Everyone have a great weekend.
Okay, thanks everyone.
Everyone, bye.